George Orwell gave it the very sinister name of the telescreen. In reality, it's just known as
Instagram.
Viva Frei, Montreal litigator turned YouTuber, and today we're reviewing a very interesting lawsuit, a class action lawsuit against Facebook and Instagram for invasion of privacy, things that you would only have imagined could have occurred in a novel called 1984, in fact occurring in everyday life in 2020. Now, for those of you who may not have already read 1984, read it. It is the best book of all time as far as I'm concerned, although in total honesty, I didn't actually read it. I listened to it on Audible. Audible, if you're looking to sponsor somebody. But for those of you who haven't read the book, who haven't read the Cole's notes, and who might not know what a telescreen is one of the concepts they have in the book. I'll just read you the description from Wikipedia to give you an idea, because I'm going to refer to it throughout this video. Telescreens are devices that operate as televisions, security cameras, and microphones. They are featured in George Orwell's dystopian 1949 novel 1984, as well as all film adaptations of the novel. In the novel and its adaptations, telescreens are used by the ruling party in the totalitarian fictional state of Oceania to keep its subjects under constant surveillance, thus eliminating the chance of secret conspiracies against Oceania. All members of the inner party, upper class, and outer party, middle class, have telescreens in their homes, but the proles, lower class, are not typically monitored as they are unimportant to the party. As later explained in Emmanuel Goldstein's book, of which Smith reads some excerpts, the party does not feel threatened by the proles, assuming that they would never rebel on their own, and therefore does not find a need to monitor their daily lives. And you know what? It seems that Instagram is even worse than George Orwell's telescreens, as we're going to find out when we read through the lawsuit, so let's just jump right into reading the lawsuit.
Wow, I just sounded like Philip DeFranco.
United States District Court, Northern District of California, San Francisco, Oakland Division, Brittany Conditi, individually and on behalf of all other similarly situated plaintiff versus Instagram LLC, a Delaware limited liability company, and Facebook Inc., a Delaware corporation, defendants. Class action complaint, jury trial demanded. All right, so as you can already see, this is going to be a class action, but bear in mind, we'll get into this a little later. Class action is just a procedural vehicle. It doesn't affect anything on the substance of the law. It is a procedural vehicle that groups together a large number of plaintiffs, hence the class. They have to abide by certain criteria, which we will get into at the end of this particular vlog, but let's just get into the allegations of fact because they are fascinating. Summary of allegations. Instagram is a popular social media platform wholly owned by Facebook with approximately 1 billion active users. Yeah, and fair warning, you're going to hear a lot of telescreen references during this vlog, and you're going to see a lot of Dr. Evil references during this vlog. Now, I don't think I am wrong in assuming that everybody knows what Facebook and Instagram is, but I'm just going to read 1 or 2 of the summary allegations of the intro so everybody has an idea as to where this is going. Instagram claims to only access users' smartphone cameras with user permission, such as when a user is interacting with the Instagram applications, also referred to as an app camera feature. For example, Instagram recently released a statement saying, quote, Instagram only accesses your camera when you tell us to. For example, when you swipe from feed to camera, end quote. Instagram claims when its camera feature is not used, it does not access users' smartphone cameras. However, Instagram does more than it claims. Instagram is constantly accessing users' smartphone camera feature while the app is open and monitors users without permission, i.e. when users are not interacting with Instagram's camera feature. Instagram has no legitimate reason for accessing users' smartphone cameras when they are not using the Instagram camera feature. By doing so, defendants have been able to monitor users' most intimate moments, including those in the privacy of their own homes, in addition to collecting valuable insight and market research on its users. Defendants engage in this conduct for one main reason: to collect lucrative and valuable data on its users that it would not otherwise have access to. You know what? I almost forgot the most important thing that I had to say in this entire video, but I'm going to save it for the end of the video, after we go through the lawsuit. My wife is looking at me like I'm crazy. The full extent and scope of defendants' conduct is only just beginning to come to light as a result of an update to the Apple Inc.'s Apple iPhone operating system, which provides notice to consumers when third parties are accessing their cameras and microphone or collecting their data. The update to iPhone's operating system was only made available to developers on June 22, 2020, and to the general public on July 9, 2020. All right, we are skipping over the jurisdiction and venue allegations. They are boring. The courts have jurisdiction. It's in the terms of service. In any case, let's just get into the substantive allegations of the lawsuit. Facebook, which was founded in 2004 by Mark Zuckerberg, Eduardo Severin, Dustin Moskovitz, and Chris Hughes, first began as a new social media platform directed towards college students. By the end of the following year, Facebook had amassed over 6 million users. In 2006, Facebook expanded its membership from college students to anyone over the age of 13. 4 years later, Facebook had not only surpassed MySpace as the most popular and most visited social media platform, but it had also accomplished the difficult task of having over 400 million active users. To date, Facebook reports over 2.6 2.6 billion active users. Instagram was launched as a social media platform in 2010 by Kevin Systrom. On the day the app launched, it was downloaded over 25,000 times. A few short months later, Instagram surpassed 1 million active users. To date, Instagram has over 1 billion active users. The lawsuit then goes on to allege how Instagram has become a large source of Facebook's revenue, and it generates in the order of, you guessed it, $20 billion in advertising revenue annually.
$20 billion in advertising revenue.
With access to so many users, defendants have claimed to value full transparency and to respect users' privacy. For example, Mark Zuckerberg claimed in an open letter, while, quote, Facebook and Instagram have helped people connect with friends, communities, and interests, people increasingly also want to connect privately. To that end, Mark Zuckerberg promised to build a, quote, privacy-focused platform and claimed to have, quote, worked hard to build privacy into all our products, including those for public sharing.
Bullshit.
Those empty promises have not been fulfilled.
As alleged herein, defendants took advantage of plaintiff and class members by secretly accessing their smartphone cameras to monitor users beyond the scope of any services that defendants agreed to provide, i.e. when users were not interacting with the Instagram camera feature. And this is where it gets really scary. Now, I have a bunch of friends who actually always put Post-its or Band-Aids or sticky tape over their phone cameras and their computer cameras when they're not using them, and I always thought they were a little eccentric. I always take for granted, regardless, that I am constantly being recorded or videotaped, but this is where it gets really scary in the lawsuit. And don't think I'm weird about that. It's just a thing. On July 25, 2020, reports emerged for the first time that Instagram was secretly accessing and spying on users through their smartphone camera without their consent. Users were able to discover that Instagram was secretly monitoring them through a new update to Apple's smartphone operating system. Apple's latest operating system, iOS update, has been declared a, quote, game changer by Forbes, specifically because it allows users to see exactly how companies access and use their personal information. Apple released iOS 14 to developers on June 22, 2020, and the general public on July 9, 2020. Among other things, the update allows users to see which applications are accessing their camera or microphone, which reportedly, quote, exposed Instagram's conduct. Instagram is not the only company who has been caught spying on users as a result of Apple's latest update. TikTok, LinkedIn, and Reddit all face scrutiny for copying users' clipboard information after Apple began providing similar notifications whenever this occurred. I would not have expected to find LinkedIn with TikTok and Reddit, but Facebook and Instagram, you're not in good company right now. The lawsuit goes on to allege that Instagram claims this is just a bug in the Apple iOS, a claim which Apple has not confirmed, but this lawsuit is very well drafted for a number of reasons. We're going to get into it after I read that allegation. Rather, Instagram has claimed that this was simply a, quote, mistake because of, quote, a bug in iOS 14 beta that indicates that some people are using the camera when they aren't. iOS is Apple's proprietary operating system. Apple has not acknowledged that there is any, quote, bug in its software that would affect the operation of Instagram. Tellingly, Facebook came under similar scrutiny for also accessing users' smartphone cameras last year. Users reported that the camera for, quote, Facebook stories, similar to Instagram stories, would open in the background while they were watching videos or viewing pictures on Facebook. Similar to Instagram, Facebook claimed that this was a, quote, bug and entirely inadvertent. And when I say that this is a well-drafted lawsuit, it's well-drafted in my humble opinion, not just because it is strong on the facts, but because it is strong on the narrative. After alleging a bunch of highly damning facts as allegations, they are not yet proven facts, they are mere allegations, they go into recounting a very damning history of Facebook. Since its inception in 2004, Facebook's core business model has been monetizing user information. As the Federal Trade Commission noted in a 2019 complaint against Facebook, quote, substantially all of Facebook's $55.8 billion in 2018 revenues came from advertising. It is therefore no surprise that Facebook's fortune rises only at the expense of its users, as evidenced by Facebook's long history of data abuse and privacy violations. For example, back in 2007 when Facebook launched, quote, Facebook Beacon, users were unaware that their online activity was tracked, and that the privacy settings originally did not allow users to opt out. As a result of widespread criticism, Facebook Beacon was eventually shut down. Just 2 short years later, Facebook made controversial modifications to its terms of service, which allowed Facebook to use anything a user uploaded to its site for any purpose at any time, even after the user ceased to use Facebook. The terms of service also failed to provide any way for users to completely delete their accounts. Under immense public pressure, Facebook eventually returned to its previous terms of service. In November of 2011, Facebook agreed to settle FTC charges that it repeatedly failed to keep promises concerning user privacy, including claims that Facebook promised users it would not share personal information with advertisers.
But wait! There's more! hang on to your seat, baby, cause this one's a screamer!
But this was not the last time Facebook abused users' data. In 2015, a journalist for The Guardian reported that Cambridge Analytica was using data harvested from millions of users' Facebook accounts, mostly without user consent. In 2018, Facebook testified before Congress that Cambridge Analytica may have harvested the data of up to 87 million users in connection with the 2016 election. This led to yet another FTC investigation in 2019 into Facebook's data collection and privacy practices, resulting in a record-breaking
$5 billion
settlement. And Instagram, under the ownership and direction of Facebook, has been no better. One could even say they have been just as Instagram has followed a similar path of repeated privacy violations as its parent company. In 2012, shortly after being acquired by Facebook, Instagram announced sweeping changes to its terms of service, disclosing that, quote, a business or other entity may pay Instagram for the use of a user's images, quote, without any compensation to the user, end quote. The changes also allowed Instagram to disclose user data to Facebook and third-party advertisers. Even worse, Instagram proposed that parents of minors implicitly consented to the use of their children's images for advertising purposes by posting them to Instagram.
Evil!
Amidst widespread protests and boycotts, Instagram claimed they would withdraw the proposed changes. Then we have some allegations about the tolling of the statute of limitations, and tolling of statute of limitations basically means pausing whatever statute of limitations might apply to the specific claims. And one of the reasons for which there could be tolling of any statute of limitations would be because of the concealment of the defendants, if it's because of the defendants that it was impossible for the plaintiffs to know they had a cause of action. And then we get into the class action allegations as to why it's appropriate to proceed by way of class action in this particular lawsuit. Plaintiff brings this action pursuant to Federal Rule of Civil Procedure 23 individually and on behalf of the following class. All Instagram users whose smartphone cameras were accessed by Instagram without their consent from 2010 through the present, the class period. Now, this is something we've already talked about in previous vlogs. In the context of class actions, the class needs to be clearly defined. It needs to have certain criteria met in order to be issued, and we go through the criteria very well in this lawsuit. Ascertainability. Members of the class is defined based on objective criteria, and individual members will be identifiable from defendants' records. Numerosity. The exact number of members of the class is unknown and unavailable to plaintiff at this time, but individual joinder in this case is impracticable. The class likely consists of millions of individuals, and the members can be identified through defendants' records. Predominant common questions. The class's claims present common questions of fact and law, and those questions predominate over any questions that may affect individual class members. Common questions for the class include, but are not limited to, the following. A. Whether defendants violated plaintiffs' and class members' privacy rights. B. Whether defendants' acts and practices complained of herein amount to egregious breaches of social norms. C. Whether defendants' conduct was unlawful. D. Whether defendants' conduct was unfair. E. Whether defendants' conduct was fraudulent. F. Whether plaintiff and class members are entitled to equitable relief, including but not limited to injunctive relief, restitution, and disgorgement. And G. Whether plaintiff and class members are entitled to actual statutory, punitive, or other forms of damages and other monetary relief. All right, and for those of you who may not know what disgorgement means, as we saw in bullet point F from the lawsuit, it basically means the legally mandated repayment of ill-gotten gains, monies that were made through unethical or illegal means. Okay, now back to finish this vlog. Typicality. Plaintiff's claims are typical of the claims of the other members of the proposed class. Defendant's conduct that gave rise to plaintiff's claims and the members of the class is the same for all members of the class. And finally, adequate representation and substantial benefits. Then we get into the claims for relief, and there are a lot of them, and they are good. First claim for relief, common law invasion of privacy, intrusion upon seclusion. Second claim for relief, violation of California Civil Code Section 1709. California Civil Code Section 1709 provides that, quote, one who willfully deceives another with the intent to induce him to alter his position to his injury or risk is liable for any damage which he thereby suffers, end quote. Third claim for relief, violation of California unfair competition law. Defendants engaged in business acts and practices deemed, quote, unlawful under the UCL because, as alleged above, defendants unlawfully monitored and spied on plaintiff and class members through their smartphone camera without consent in violation of the California Common Law, California Constitution, the Federal Wiretap Act, California Civil Code Section 1709, the California Consumer Privacy Act, and California Penal Code Section 631-32. This house is clear. Fourth claim for relief, violation of the Wiretap Act. Fifth claim for relief, violation of the California Invasion of Privacy Act, California Penal Code Section 631A. Sixth claim for relief, violation of the California Invasion of Privacy Act, California Penal Code Section 632. Seventh claim for relief, request for relief under the Declaratory Judgment Act. And the declaratory orders that the plaintiff is looking for are pretty self-explanatory: that the defendants have invaded her privacy, that they've broken the law, that she's entitled to equitable and injunctive relief, etc., etc. And the plaintiff is in fact seeking an injunction enjoining the defendants from collecting the data in the allegedly unlawful manner pending a final resolution of this dispute. The court should also issue corresponding injunctive relief, including but not limited to enjoining defendants from engaging in the unlawful conduct alleged in this claim and requiring defendants to cease further monitoring of plaintiff and class members and other appropriate equitable relief, including but not limited to improving its privacy disclosures and obtaining adequately informed consent. So that is the lawsuit, and it is definitely a to be continued, because there will definitely be a continuation of this, and I will definitely be there vlogging on it when it happens. But I just want to leave you with one final note as relates to recording conversations. Before ever recording a conversation, you have to first verify if the jurisdiction is a one-party or two-party consent state, because if it is a two-party consent state, you cannot record a conversation to which you are a party without the consent of all of the parties. If it is a one-party consent state, you are in fact allowed recording the conversation, even if the other party does not know that you are recording. But as far as I understand, under no circumstances are you allowed intercepting a conversation to which you are not a party. So either way, if the allegations in this lawsuit turn out to be true, Facebook and Instagram are going to have a lot of explaining to do. We will see where this goes, but if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below because it feeds the algorithm. If you want to support the channel, all of these support links are in the pinned comment. We've got PayPal, Patreon, Subscribestar, YouTube membership, we've got merch, politics ruins everything, but more important than any of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out. Booyah! Whoa, whoa, whoa. I almost forgot to come back to the point, the thing that concerns me most about this lawsuit, but in order to understand that, we first have to go back to paragraph 31 and something I said on Twitter. As a result, defendants have been able to secretly spy on users, including plaintiff and class members, during intimate moments and in private places, such as their bedroom, to gather lucrative data to increase its advertising revenue. Now, if you don't already follow me on Twitter, consider following me on Twitter. I occasionally say non-dumb things there, and as relates to this vlog, I wrote the following. Today's vlog is on the Instagram, Facebook class action lawsuit. It's very interesting, and I'm thinking the scarier underlying motive, interest, is not advertising revenue, but political influence. It may seem naive or superficial, but I don't really think I care about the advertising revenue from a substantive point of view. I care more about the political influence that can be used by Facebook and Instagram as a result of this type of spying. And it is by no means a purely hypothetical concern. Just listen to some of the things that Mark Zuckerberg just said in an interview.
Now, you said on election day it's over, but it well might not be, right?
I think the dynamic that you're talking about is really important, which is that we may not know the final result on election night. One of the things that I think we and other media need to start doing is preparing the American people that there's nothing illegitimate about this election taking additional days or even weeks to make sure that all of the votes are counted. In fact, that might be important to make sure that this is a legitimate and fair election.
If Facebook and Instagram can spy on you through your camera, through your microphone, when you're not even using the app, they would know everything they need to know about who they need to target for political purposes, and that is, as far as I am concerned, much scarier than any corporate money-making advertising scheme. All right, and that really is the end of the video. Take care of yourselves, and see you in the next vlog.